it would certainly amount to an acceleration if I say that Section 497 of I.P.C. pertaining to an adultery must be abolished. But certainly, we won't be overstating if we say that it needs to be amended suitably at the earliest to meet the present circumstances, because we are now living in 21st century, not in 19th or 20th century. We are totally dumbstruck to see that even after so many years of independence, this most discriminatory section, not only in I.P.C., but in our entire criminal law, which imposes punishment on men alone, even though woman is fully consented for it, or even loved him as an adult, still remains untouched after so many years. Why a married woman alone has been given a blank check of open exemption to indulge in free sex with as many men as she likes and yet not be punishable? Can on earth there be any such discriminatory law which openly discriminates between men and women and imposes punishment on men alone? We know that even in England itself, an adultery is not a criminal offence because an I.P.C. is their creation. But in some European countries, an adultery is mildly punishable. For instance, in France, a wife guilty of an adultery is punishable from minimum 3 months to maximum 2 years of imprisonment. Husband, however, has discretion to end her sentence and take her back. In Pakistan and most Islamic countries, an adultery can be punished with death also. We must learn something from the Penal Code 1932, Section 497, applicable to Jammu and Kashmir, which equally punishes both the parties. Similarly, in Korea, both husband and wife are equally punishable for adultery under Article 241 of Korean Criminal Code. Fifth Law Commission of India in 1971 had recommended that the retention of the Section 497 in its present form, with the modification that even the wife has sexual relation with a person other than her husband, should be made punishable for adultery. Even the Supreme Court of India in Saumitri Vishnu versus Union of India, AIR 1985, held that it is commonly accepted that it is the man who is the seducer and not the woman. This position may have undergone some change over the years, but it is for the legislature to consider whether Section 497 should be amended appropriately so as to take note of the transformation which the society has undergone. Similarly, Committee on Reform of Criminal Justice System in 2003 has also recommended that, in view of the fact that adulterous relationship cannot take place without the consent of the married woman, it is highly discriminatory to hold only the man guilty of the offence without making the adulterous woman liable for her infidelity. Apart from this, National Commission for Women and 156 report of the 14th Law Commission has also recommended the amendment in the Section 497 of I.P.C. Once Justice S.N. Dhingra of Delhi High Court said that We are living in an era of equality of sexes. Constitution has also provided equal treatment to be given irrespective of sex, caste and creed. An unemployed husband who is holding an MBA degree cannot be treated differently to an unemployed wife who is also holding an MBA degree. Does this concept of equality cannot apply in this case of adultery also? A crime is crime, whether it is murder, theft or an adultery. If a woman is punishable for murder, theft and any other offences, then why not for adultery also? Why not for adultery also? To be brutally honest, if there is one section in I.P.C. to which we detest the most, it is obviously section 497. I am saying this not because I am men, but as a human being. No man can even stare a woman continuously without her consent. Leave alone the question of having physical relationship. At least now our government must take action and initiate necessary changes in it by making it gender neutral. Media should also play its part in this regard as by debating more vigorously and prominently to draw the attention of our lawmaker in this regard. Thank you very much.